Another aspect of the Constitution designed to account for the natures of man and government, to keep it properly contained, is the various checks and balances that were established. Already we see the recognition that the U.S. is a federal polity, with the existence of institutions possessing their own rights and authorities separate from the government. We already see that these serve as a check to the federal government, but there are many more. Consider the following. In Congress, the House checks the Senate and the Senate checks the House. Both must agree on legislation. The President checks Congress with his veto power. Congress checks the President with its ability to override a veto. The President must receive approval from the Senate for a variety of actions. By himself, the President was delegated the authority to execute the laws of the land, grant reprieves and pardons, receive ambassadors and public ministers, commission all officers of the United States, convene Congress in a special session, and if Congress okays it, the President alone may make appointments to inferior offices without consent from the Senate. Last, the President is to be Commander-in-Chief of the Armed Forces after Congress calls the armed forces into action. Notice the armed forces are controlled by the civilian part of government. History and the nature of man and government teaches that when executives have the power to declare war and power over the armed forces, it is a lethal combination. A quick read of Article 2 will show that the President does not have too many significant powers, only to execute the laws and, obviously, to be Commander-in-Chief of the Armed Forces. After reading Article 2, one should begin to wonder what happened, because clearly the President of today exercises much more power than what is listed constitutionally. Other checks and balances include the role of the Supreme Court. In Article 3, Congress is given an additional power to serve as a check on the Supreme Court. States have the ability to check the federal government through the process of nullification. The people of the states can also check the power of the federal government through the ballot box, and more. Further evidence of the framers taking into consideration the above-mentioned principles is the Bill of Rights. The language of the Bill of Rights makes it clear that the people of the states understood that rights are pre-political, that they exist before any establishment of a government. In other words, government is not the source of rights, but, as expressed in the Declaration of Independence, God is. The fear of centralizing more power than what was delegated in the Articles of Confederation into this new government, a fear based on a Judeo-Christian understanding of the nature of man, led many to insist on a Bill of Rights for added protection. Protection from what? Protection from this new federal or central government. Finally, the fact that the states created a republic, not a democracy, indicates they took into consideration the nature of man and government. In a republic, particularly a constitutional republic, the law, or the Constitution, is the ultimate source of civil authority. While a republic can have multiple levels of laws, some of which may be enacted by a majority, there is usually one supreme set of laws which are preeminent over all others. Depending on what that law is based upon, it can be a much more limited system that is less likely to become tyrannical. For the United States, this supreme set of laws, which we call the Constitution, cannot be changed by a majority. It exists, among other reasons, to protect the rights of the minority from the majority. It also exists to protect the governed from the governors. The Constitution can be seen as the law that governs those who govern us. One often hears, and many people refer to, the United States as a democracy. But the United States, as mentioned, is not a democracy. It's a republic. In a democracy, the majority is the ultimate source of civil authority. Majority rules. That means, in a democracy, man rules. Man decides what is right and what is wrong. Right and wrong is determined by majority vote and therefore is relative. Right and wrong changes as majority opinion changes. Thus, the primary flaw in democracies of any type, direct or indirect, is that they allow and legitimize immoral and unethical actions. Democracies are notorious for allowing one group, a majority, to violate the rights and property of other groups, the minority. If the action is favored by a majority, the action is acceptable, even praised. In a democracy, government can demonstrate no absolute truth or justice, only the will of the people at the moment. A democracy, therefore, is the epitome of moral relativism and is fittingly referred to as a tyranny of the majority, because the rights of the minority are at the mercy of the majority. This is one of the reasons the Bill of Rights was added to the Constitution. The Founding Fathers and the founding generation loathed democracy, calling it mobocracy. Benjamin Franklin described it as two wolves and a sheep voting on what's for dinner. James Madison in the Federalist Papers said, "Democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property." Interestingly, the U.S. Army Training Manual in 1928 says this, quote, "Democracy, a government for the masses, authority derived through mass meeting, result in mobocracy. Attitude toward property is communistic, negating property rights. Attitude toward law is that the will of the majority shall regulate. Result in demagogism, license, agitation, discontent, anarchy." End quote. However, by 1952, the Soldier's Guide from the U.S. Army Training Manual says this, quote, "Meaning of democracy. Because the United States is a democracy, the majority of our people decide how our government shall be organized and run." End quote. Apparently, and sadly, Americans have forgotten the lessons of history and the admonitions of our forefathers. Nevertheless, the federal Constitution, as well as state constitutions, created republics, a system that more effectively protects our rights. These principles, as well as various pragmatic decisions, shaped the Second Constitution of the United States. Because there were so many people with diverse backgrounds and experiences, creating a written constitution that would spawn a new level of government was not an easy task. The end product contained numerous compromises. We will quickly address a few of these. A compromise that some say saved the Constitutional Convention was the Great Compromise. It was an agreement that large and small states reached during the Constitutional Convention of 1787 that in part defined the legislative structure and representation that each state would have under the United States Constitution. Small states wanted a unicameral, one-house legislature, with each state having an equal vote, while large states desired a bicameral, two-house legislature, with representation for both houses based on population. The difficulty between the small and large populated states had to do with political power. Neither wanted to be in a position where others could threaten their sovereignty. The impasse ended when both agreed to Roger Sherman's compromise proposal known as the Great Compromise, or the Connecticut Compromise, which led to a bicameral legislature with representation in one house, the House of Representatives, based on population. The more people a state has, the more votes it has. And a second house, the Senate, with equal representation, 2 votes per state. Following the Great Compromise, northern and southern states disagreed on whether or not slaves should count as part of the population in regards to representation in the House and for taxation purposes. The North did not want slaves to be counted as part of the population in slave states. Why? Because if slaves were counted as part of the population, then slave states would have greater representation and thus political power in the House of Representatives. The South, the slave states, of course, wanted to count slaves as part of the population in order to have greater political influence in the House. When it came to taxation, the two sides flipped positions. The North wanted to count slaves as part of the population so the South would pay more in taxes, whereas the South did not want to count slaves as part of the population. In the end, the disagreement was reconciled by the 3/5 compromise. Slaves would count as 3/5 of a person for purposes of representation and taxation. 2 other issues that led to a compromise had to do with the slave trade and the Commerce Clause. More on the Commerce Clause in a later video. Northern states wanted to prohibit the slave trade, and southern states feared that the Commerce Clause could lead the new federal government to levy export duties on its tobacco, rice, and other crops. The compromise stated that Congress could not prohibit the slave trade for 20 years, which it does when those 20 years are up in the year 1807, and could never levy duties on exports. Finally, the Constitution, when finished, consisted of a preamble and 7 articles. The preamble, which initially began as "We the States of the United States," was changed by the Committee on Style to "We the People of the United States." It, the preamble, was understood by everyone in the 18th century to have no legal status or standing whatsoever. No authority is given to do anything in the preamble. It is merely introductory and declarative. Those who reference the preamble as a source, as evidence of granting authority when claiming Congress has a particular power, do so ignorantly. Following the preamble are the 7 articles. Article 1 addresses the legislative branch. Section 8 of that article lists the powers Congress has, which means Congress may draft bills that pertain to these areas, but nothing else. More on that later. Section 10 of Article 1 lists things the states agree not to do. Article 2 focuses on the executive branch, dealing with the president, the executive, and his powers. Article 3 is about the judicial branch. Article 4 addresses miscellaneous items dealing with the relations among the states and expresses that all states are required to have a republican form of government. Amending the Constitution is the focus of Article 5, as it explains 2 ways of doing so, one through Congress and the other through the states, which has yet to be done. Article 6 also contains some miscellaneous items, as well as the Supremacy Clause. Again, more on that later. The 7th article deals with the ratification process. Following the articles comes the amendments to the Constitution, the first 10 being called the Bill of Rights. The next video will continue to look at the nature of American civil government, the nature of the Union of the States as it becomes the United States of America. We will look at the ratification of the Constitution as well as particular clauses that caused and have created great concern.